to the HR Legal Lowdown, where we decode employment law topics in a short video. Today I am joined by Nicola Prestia, partner here at HR Legal, and today we're going to talk about dual employment. So Nicola, can you tell me what dual employment is?
Thanks, Alex. Hi, everyone. So dual employment is really simple. It's basically where an employee has two different jobs for the same employer. And it's often used to fill gaps or where part-time employees want to pick up extra shifts, so they take up a casual position. So we do see it a lot in certain industries, particularly in local government or larger organisations where there might be different roles available to one individual.
Mm-hmm. So is it actually allowed under the Fair Work Act?
It is. There's no prohibition on dual employment, so you can engage in that provided it is done properly, because there are still some pitfalls. So it is important that each role is separate and clearly distinct from the other, and ensuring that the employer's enterprise agreements, if there are any, or other contracts don't restrict having dual employment for that particular individual. And of course, there's also obligations under health and safety laws. So, it's probably not advisable to have a full-time employee having a second full-time job.
Sure.
They're more likely to be, fatigued or overworked in that case. So provided we keep those matters in mind, dual employment is absolutely available to employers.
Great. So you mentioned some of the legal pitfalls. Can you talk to that a little bit further?
Yeah, sure. So we've actually had some cases on this very point. One involved the local council in Mornington here in Victoria, and another Australia Post, which is a large national employer. And in both of those cases, the employees actually said that their two roles were actually one and therefore continuous. And were claiming overtime and other entitlements that could arise if you considered both jobs to be the same. So, for example, if they worked one shift in the morning in one role and then a second shift in the afternoon, they said that should have all been considered together, and overtime could apply.
Right. So documentation is always key. No surprises there. What practical steps should employers take when they're thinking about this model?
Yes, lawyers love paperwork, as you can imagine. So if you are engaging or having employees employed in two different roles, i.e. dual employment, it is important by making sure that those two roles are truly distinct and that it is documented, so having separate employment contracts. But going beyond just what's in writing, ensuring that the actual practical reality is also distinct, so different pay slips, different employee numbers, different managers, and just keeping them completely separate is certainly ideal, and avoid overlapping the responsibilities or having that grey area as well. And most importantly, get advice early if you're not sure. That's exactly what HR Legal is here for. Better to get it right from the outset than try to fix up a problem later.
Absolutely. So what I'm hearing is dual employment can be a useful tool, but only if the legal structure and documentation are watertight.
Absolutely. Don't cut corners.
Well, thank you so much for your time today, Nicola. My name is Alex. I am the Business Development Manager here at HR Legal, and that was the HR Legal Lowdown.